And just to go back, we left two things actually off the last slide. We've also obtained orders in divorce proceedings in Supreme Court, and also, as Jennifer mentioned, when youth are charged in criminal court and a placement is made about and a decision is made about custody placement, we have been successful in obtaining special findings orders also in those cases. This is reunification. The finding that reunification is not viable with at least one parent. To reemphasize, it is at least one parent. The Second Department here in New York has made it very clear that that is the rule. Here in New York, it's very clear in our appellate law that a child living with a parent where that parent has not been neglectful in any way, but who has been abused or abandoned or neglected by the other parent, is potentially eligible for a special findings order. So the fact that they have one non-neglectful parent is not a bar. As Lenny mentioned, I've screened and represented hundreds of youth, and I have never had a young person who I met at the juvenile docket, upon interviewing them about why they came to the country, really disclose, well, first of all, I've never had someone, say that they came with any expectation of relief. In fact, most youth are shocked and very disbelieving, I think, throughout the process, in fact, that they may be eligible for relief, that there may actually be something that can allow them to stay permanently. But it's also, you're talking about very traumatized youth, it's also very common for a young person not to disclose abuse, neglect, abandonment in your first, second, even third interview with them. And that's true even when it's a very skilled, very sensitive interviewer working with a child. And so that's just something to think about. I think the privilege of these cases, I really do feel like it's such an amazing privilege to get to work with youth, is really having them share their stories with us and trust us with their stories. And so these cases are really all about those stories, getting as many details as you can in the most sensitive way you can, but also really, being forced to probe and understand why a client came, what their home life was like, what their life was like, school, work, relationships with parents, relationships with other family members. Virtually every child that we're seeing right now in immigration court has horrific stories of the violence and trauma that they've suffered and seen. Most of them have seen classmates murdered. Many of them have themselves been raped, hurt on the journey. There are many things that they may be sharing with you at the first meeting, but it's also possible that these stories really do, that a client may open up to you over time. So that's my cautionary sort of note about really trying to understand fully. So the next few slides are really getting into the New York State law about abuse, abandonment, neglect, and similar bases under state law. This is all about the statute, all about case law, and we cannot emphasize enough how important it is to do your own research about case law, because every factual scenario in family court is so different, and the facts underlying different cases are so different. And it really is about not just what we think of when we think about abuse or neglect, but what the statute says and what the family court is used to adjudicating in all these various cases. So neglect is under the Family Court Act. The FCA is what we'll use as the abbreviation. Under 1012F1, it's talking about a child being in imminent harm, faced with imminent harm, or having been harmed by a whole host of things. The first section is the parent's failure to exercise a minimum degree of care in supplying adequate food, clothing, shelter, or education, though offered, or medical care, though able or offered reasonable means to do so. What's important about that and the underlying part is that poverty alone is not neglect. And again, that's very important. You have, I'm sure, seen many published decisions recently that really talk about that. If a parent doesn't have the means to care for their child, the fact that a child is living in real extreme poverty is not necessarily neglect. And so it's really important to look at some of these other things to establish if in fact the child has been neglected, that they have. Some of the things that often are the case. So although maybe someone using, for example, their salary on alcohol instead of necessary items, and that's something that, again, a child may disclose to you over time, that part of the reason they didn't have food was because one of their parents, who was very depressed about not having work, was then spending whatever little money they did have on alcohol or other drugs. So that's a way that, understanding what's behind the poverty can help. Similarly, excessive corporal punishment. Under New York law, a single incident of excessive corporal punishment, if it's serious enough, can actually rises to the level of neglect. It really depends on the harm that the child is placed in. So in a case, for example, a parent hitting a child with a belt buckle near their eye, that is a single incident that would rise to the level of neglect. More frequently, neglect is established or a repeated pattern of excessive corporal punishment. Similarly, domestic violence. There's case law that explains that a parent who commits acts of violence against the other parent in the presence of the children, slamming doors, throwing things in front of the children repeatedly, et cetera, putting them in harm's way, that rises to the level of neglect. Simply being forced to leave school at a young age or being forced to work at a young age does not necessarily rise to the level of neglect under New York law. You have to really look at, was school free? Was it compulsory? Was the child who was working in very dangerous conditions? Were they forced to return to work after being injured on the job without safety equipment? Those sorts of things. And in itself, a parent's misusing drugs or alcohol to the extent that they lose self-control is also constitutes neglect.